into the unknown, down the rabbit hole, where it stops no one knows. We're going headed into the unknown. Na, 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 na.
Hi, everybody. Welcome back. So I did not expect to be doing another live today, but here we are. I told you guys as soon as we had the order from the Supreme Court that we would do a live, so I picked up the kids, I popped in some other lives, listened to some other commentary, and then I'm like, all right, here we go. So we will not be on here for a super long time because shit, we did 5 hours earlier. I'm exhausted. I'm like, oh, I'm just like, let me put my head down for a minute. And so, but we're gonna do some. We're going to do a little bit of a recap. I know, rambling. I know. You're like, told you. So once you close the stream, they'd release the decision. It was so quick. I'm afraid to ask. So hello, everybody. Hi, Teresa. Hi, Cindy. All eyes on Delphi. Hi, Marissa. Hey, Just Deb. And rambling. I said hi to you, the Lodger. Hi, Grace. BR the Star. Jinjo Snaps. Let's go. Hey, Mary. Hey, Shaz. Inspector Gadget. Hey, Nancy, welcome back. All right, hi to everybody. So let me just put this up on the screen. If you guys have not heard the order from the Supreme Court, I'm like super, like, whoa, what's going on with the light? Hold on, let me turn my camera off. Order from the Supreme Court came down at 3:44 p.m. Eastern Standard Time. So let's get this up here on the screen. And we know that with the original action, they were essentially seeking 3 different things. 1, to have Baldwin and Rosie reinstated. 2, to commence with once they were reinstated, to commence with the trial within 70 days of that. And then 3, to have Judge Gull removed. So published order, I mean, let's think. So they went in at 11. They were done at a little bit after noon. It took them approximately 3 hours and 40 minutes to make the decision of what they were going to do. So they have ordered the relator, Richard Allen, seeks relief from this court under the rules of procedure for original actions. The relator has requested a permanent writ of mandamus asking this court to 1, order the trial court to reinstate his former trial counsel, attorneys Andrew Baldwin and Brad Rosie, as court-appointed counsel. That's a big thing right there. 2, order the trial court to commence relator's trial within 70 days from the issuance of the writ. And 3, remove the special judge from relator's case and appoint a new special judge. Having considered the written submissions and having heard the arguments of counsel, which we heard twice today, a majority of the court votes to grant the petition for writ as to relator's request to reinstate attorneys Baldwin and Rosie as his court-appointed counsel. What that's telling you is it was not a unanimous decision. They only needed 3 out of 5, but it was not. It could have been 4 out of 5, but it was not unanimous. It was a majority vote to reinstate Baldwin and Rosie. The court unanimously, all of them, declined the other relief sought, which means they unanimously said we're not touching the 70 days and we're not touching removing Judge Gull. So Baldwin and Rosie back on the case, officially back on the case. So what does that mean? Yeah, you only need the majority, so there it is. I'm afraid Gull is going to have her bias and deny all the defense motions. It would be a really bad idea for her to do that. I know, Anon, and me too. I was so shocked that it came back so fast, but of course, like I literally got off the 5-hour live, went inside, used the restroom, made some nachos, sat down, and then I was getting messages, and I'm like, I just, come on. I'm like, I can't do this right now. I gotta go get kids. But it would be a really bad idea for her to just deny anything and everything just because. I mean, there's a few different things that are going to happen, or could happen, I should say. And I don't have any idea which one it's going to be. But so first and foremost, the Indiana Supreme Court will actually do a written opinion. So this is the court order, but there's going to be a written opinion which will essentially say why they made the decisions that they made. Based on that, I think we'll be able to see a little bit more of what the future holds via motions wise. So for instance, if they simply say, which I figured they would with the 70-day anyway, you can take that up at the trial level. We reinstated you. Now you guys go file your speedy trial. We don't need to take care of that for you. You're a big boy. You know, you can handle it. The other thing is with the removal of the judge, I didn't really know which way they were going to go with that. I was thinking they'd probably keep her and send that also back down to the trial level, where now, but this is a question that I would love for an attorney to answer for me, is Rosie had put in the motion to have her disqualified. Does that just stand? Like, does it stay there? Does he have to resubmit that? Like, how does that kind of work? So I'm curious if he has to resubmit to request for her to be removed, or if they have to re-request that. So my thought is when we get like the written opinion, it's going to really kind of come down to those are things that can be handled at the trial court level. We don't need to overstep where we're at. We just needed to put these two back and kind of reset things back to, you know, the October 19th, where now, you know, they can make the decisions on how they want to. Nachos sound good. Give me 1 second. You guys, a dog scratching at the door. Okay. So my thought is that she's either going to make the decision that, and like I said, depending on how this written opinion ends up looking, she's going to make the decision that she's just going to go ahead and she's going to hold the hearing herself to determine, you know, what she should have done the 19th and given them notice to, that she's going to hold the hearing to have them disqualified or to have them, you know, deemed grossly negligent, incompetent, all the things. She could do that. My personal opinion is I think that would be a really bad look, because I don't know. I mean, she could do it. I just think it would be a really bad look. Like, they got back on after everything that happened, and you're still going to try to do that. And the Supreme Court justices literally said, like Justice Rush said, the one thing that she discussed was the press release, and that was out before there was a gag order. The other thing that she discussed was the fact that she essentially accused them of lying about Richard Allen's conditions. And she says, by saying that it was somewhat not true, but then that means that it is also somewhat true. And then the other attorneys, which I don't know if we call them the new attorneys now, because now they're the old attorneys. That's going to be interesting. But that Scremin and Labrato also agreed that something was going on with the way that he was being treated. So obviously there's something to that. The other two things would be him accidentally sending Brandon Woodhouse the thumb drive map, and then the crime scene photos. Well, the crime scene photos, they already have somebody who is being prosecuted for unlawfully taking those pictures. So I don't know how they're really going to put that too much on Baldwin. It was more about the, what do you call it? Like, how would you say it? Like the repetitive issues of, you know, lack of listening to her. And like the justices were like, yeah, like it was insubordination more than it was anything anything to do with incompetence or gross negligence. So I'd be surprised if she tries to bring those things back up, since the Supreme Court, even though they didn't rule on anything to do with it, they did comment on it. So I don't know. So that would be one option. She can go, okay, well, now you guys are back on. Good job. And here we go. We're going to go ahead and have that hearing that you guys wanted to have so bad. That could be one. The other thing could be, and I mean, it could be all of these too. The other thing could be where Baldwin and Rosie go in and they resubmit the petition to have her removed. She originally has to say, I will either recuse myself or I won't. If she doesn't, then they can take that up. Kyle, thank you, Kyle. They could take it up at an appellate level and say, hey, we want her recused because we believe she's biased, or we want her to recuse herself because we believe she's biased, so on and so forth. That's a possibility. The other possibility would be that they all just go into court and they all just get along, and Richard Allen's attorneys, his now new / old, like the OG, his OG attorneys could just say, we're filing for the speedy trial. Give us the 70-day trial. Let's rule on the Franks memo, and let's just get this done, and we don't have to see each other again. So I think that's probably a really good possibility, because anything else is just going to continue to push this whole thing out. So I think they may just kind of go that way. Now, another option, which I don't know what you guys think, but another option would be that Judge Gull just says, well, since they're back, I am now going to have the perception. I mean, she wouldn't say she's biased, but maybe she would say like the perception of bias, and she would recuse herself. Or she could easily say, with the health issues and now this paper pushing job, like, I'm just busy and I don't have time to do this type of trial within 70 days, so I'm going to have another judge do it. So there's quite a few different things that could happen. But what I do foresee happening is a very quick turnover here on a lot of things that we waited on, like with the Franks memo and the motion in limine on the bullet. There's so many things that she's going to have to get through that she never did once they put in the fact that they want a speedy trial in 7 days or 70 days. So maybe just by them doing that, she'll be like, yeah, I don't have time to do that, and I'll just go. She is stubborn, though. She has so much pride that I just don't. I don't know. But she did set up that health thing. She said that was an absolute setup. Not to say she wasn't sick, but it was an absolute setup that came to the public. Like 3 weeks after she was in the hospital. Like the public didn't even know. Nobody knew. It didn't matter. And she made sure, or, her people made sure that the public learned that she was in the hospital 3 weeks prior when nobody was even paying attention. So I think there's a chance that she may step down and just use the, I think I can't, there's no way to put this into my life right now, into my calendar. So, I think if what the defense attorneys were saying is true and they were, ready to go to trial, January 8th, I think we could see some things really speed up now. And then we have Nick McClelland, who goes and throws out all these additional charges today that he has to get approved, which I don't think will be an issue. I think she'll approve them very easily. And then I don't know how, I should have looked that up before I went live, how long before the trial that McClelland would have to say that he is going for the death penalty. So I believe it's Rosie that is death penalty qualified, and I don't believe in Indiana you have to have 2. I think you only have to have 1. Those are things I am not 100% sure on. We'd have to go find them. So bottom line, they're back. She's still there, and we're going to start to see some things rocking and rolling. I do believe that they have had some motions and things ready to go for the readiness of, like, we're back on, let's just start going. Like, I think that we're going to see some things. Baldwin is death penalty qualified. Is he? Okay. I wasn't sure if Baldwin, I thought Rosie was, but I wasn't sure about Baldwin. This is a great decision for the Constitution and all of our rights. I absolutely agree. Okay, both qualified. Okay. The new charges, so what they ended up doing was adding on a kidnapping charge for each of the girls and a murder one charge, which is, intentional, like an intentional homicide, intentionally and knowingly, which goes to, it's worded so weird in different states. So it's like, I consider it like a murder one because it's like the top type of, it's the top murder charge you can get. Alibi, thank you. Thank you for gifting 10 memberships. And welcome to all the new members. So, all right. So I'm gonna pull up a couple. I pulled a couple clips to show you guys, and then my lovely friend ATS sent me a couple too. So, yeah, not enough green in here. Let's make it greener. Wow, it was so fast. I know. It was so fast. All right. Well, hello to everybody that just popped in, by the way. And we'll start with this, and we'll start with Court TV. I think I turned on the sound when I clicked the little button, so that's so stupid. Like, StreamYard just needs to make it so there's sound, like always. Just turn the dang sound on. The Rockaways. This is why I think it's going to be really important that we go to what the written opinion was. Hi, Jen Leo. We go to what the written opinion is, because then we're going to see because my thought, obviously we don't have it, so my thought is that they're just going to say these are things that we do not need to provide because they can be handled at the trial court level in a timely manner, versus that being reinstated. There was no way to make that happen without the Supreme Court saying, let's do it. So I think now they're like, okay, you guys are back in place. Go do what you need to do at the trial court level. Okay. So this is Court TV. Barbara McDonald is on, and she was in court today. She's the one who had the photo, that posted the photo. I'll show you guys of Brad and Andy in the lobby area. So she had posted that earlier, and then she caught a little Bob Mata hanging out. Little Bob right there. A crow does not pick another crow's eyes. That's what I fear happened here. Oh, it's kind of a dark saying. They are reinstated as court-appointed attorneys, which means they're back to being his public defenders. They are not pro bono. Yeah, I think she's going to have to. She's going to have to definitely mind her P's and Q's for now. And if they actually can, they file to get the speedy trial going, then like they could just get it over with and be done and move on. But, hey, Case Chaser. Oh, wait, shoot, where'd they go? There it is. Okay.
News from Indiana in the Delphi Murders case.
The state Supreme Court has made a key ruling in Richard Allen's case. Court TV senior producer Barbara McDonald was inside the courtroom for today's hearing and has the breaking news update. All right, Barbara, great to see you. Thanks for joining us. What can you tell us?
They have already issued a ruling. It took them 3 hours and 45 minutes after the hearing ended today to file a published ruling with the court. Those of us who were in attendance in the court today did get an update about that.
Okay, right there. Does that not make it seem to you that anybody who was in the court today knew that there was going to be a ruling coming out like immediately? Because that's what that sounds like to me. Like, just stay tuned. We'll have you guys an answer like this afternoon. How the heck did they end up knowing that? Because like all the chief justices had left, or all the justices had left. So I don't know. That's really interesting to me. Sound and Silence says they do not want to go the Odin angle, so I think they will try to remove them again. If she tries to remove them, which, like I said, it's possible that she determines to have the hearing and then her findings are still her findings, that she was going to have regardless. It's going to show so much bias, and then we're going to be back in the same position we were before with going to an appellate court if the new attorneys are, if he gets found guilty with the new attorneys. I don't know. I'm thinking right now, and it was Ivy Rose said this earlier. She's, I'm thinking right now that they're probably going to go in there and they're going to just play nice and get it done, and like everybody move on. I don't know. That's my thought, and that's what I think is going to happen. Kara was notified there was an order, yeah, but like this is before they even left the courtroom. That's what Barbara McDonald's saying. She's saying like this is, those of us that were here. Listen, those are about just listen to her. I can't talk, obviously.
And basically, they are reinstating that, and basically they are reinstating the original defense team of Bradley Rosie and Andrew Baldwin. That was one of 3 requests that Richard Allen had. The other 2 requests to replace the judge and to set the trial within 70 days of their decision, they unanimously deny. It is also worth noting it was a majority opinion, not a unanimous opinion, that restores Bradley Rosie and Andrew Baldwin. Both of them were in the court for today's hearing. They were not part of the actual hearing. They did.
So, oh shoot, I was going to show you. In case anybody who didn't watch this earlier, right here on the right-hand side, this is Brad Rosie, Andrew Baldwin sitting next to him, and right here is Bob Mata. So like front row seats. She said it took 3 hours and 45 minutes to get a written order. I'll play it again. Let me go back. To get a written order, but those of us who were in the courtroom we'll listen to exactly what she
today said. To file a published ruling with the court. Those of
is hearing and has the breaking news update. All right, Barbara, great to see you. Thanks for joining us. What can you tell us?
They have already issued a ruling. It took them 3 hours and 45 minutes after the hearing ended today to file a published ruling with the court. Those of us who were in attendance in the court today did get an update about that. And basically they are.
Those of us that were in the courtroom today did get an update about that. So that makes me think that they got a heads up like, hey, there's going to be an order coming down. Scrumman and Librato, I do not believe so. I have not heard anybody mention them. I've heard Barbara McDonald, Murder Sheet, Bob, Frank Meister, Becky, Mike, and Tara from Libby's family. Who else did I hear? Brad and Andrew Baldwin. I think that's what I heard. So I don't know. I don't know who else was there.
Reinstating the original defense team of Bradley Rosie and Andrew Baldwin. That was one of 3 requests that Richard Allen had. The other 2 requests to replace the judge and to set the trial within 70 days of their decision, they unanimously deny. It is also worth noting it was a majority opinion, not a unanimous opinion, that restores Bradley Rosie and Andrew Baldwin. Both of them were in the court for today's hearing. They were not part of the actual hearing. They did not argue anything on behalf of Richard Allen. This is a picture I took of them prior to the hearing beginning. They looked confident. They looked comfortable after the hearing. They appeared relaxed. They were congratulating, or not congratulating, but they were talking with the attorney who did argue on their behalf, Mark Lehman, and they were exchanging hugs and handshakes and seemed to feel like everything went really well. And apparently it did go well for them today, because it took just 3 hours and 45 minutes for the court to come back with a majority opinion that Bradley Rosie and Andrew Baldwin should in fact be reinstated. Now, this means that Richard Allen's trial, which is scheduled for October of this year, is going to go forward with these attorneys and the same judge who removed them and who these attorneys have accused of being biased, not only against them, but also of their client. So a lot of very interesting developments. It was a rare hearing at the Supreme Court to take up a matter like this prior to it even getting to trial. And then to come back with a ruling so fast, everybody expected a ruling within a couple of weeks, which they thought would be very fast. This took, again, 3 hours and 45 minutes. Michael?
Okay, so does this make at law now. So what happens is what the case law, it would be case law and from the Supreme Court that will be able to be used in future Supreme Court hearings. So let's just say there's another case where a judge decides sua sponte that any of the attorneys, the prosecutor or the defense, is grossly negligent and doesn't hold a hearing and throws them off the case. And they decide to take it to the Supreme Court. The attorneys, like how they argued this morning, would then be able to go up there and be like in, Richard Allen versus Indiana, this is what, came up, so on and so forth. They would be able to cite this as something to say, hey, a judge isn't allowed to do that. And this court, being the Supreme Court, has already made the decision that it's not allowed to happen. Julio, yeah, they already came back. They already ruled that Baldwin and Rosie are back on. Yeah, order's already there. We haven't seen the written opinion, which will also matter when it comes to that. And yeah, and Christine popped in and said, FYI, the Innocence Project is taking on the Scott Peterson case. So that's also very interesting news. Side note, Chad Daybell's attorney, John Pryor, if you guys are following that case, he filed a motion to withdraw as counsel, and Judge Boyce said, yeah, no, nice try. You're staying, and that's it. So there's so many little interesting things that are just happening. It's just crazy. Okay, let me go back to this.
Judge.
Well, Barbara, let me ask you this. We just saw there were 5 of, we know, the justices sitting to make this decision.
Correct.
And I just wanted to ask your thoughts, because I know you are all things Delphi and you have followed this case. You've been intimately involved. What do you think of the fact that it was a split decision, that 2 of the requests were denied, that it is simply these attorneys go back to representing Allen, which I think is Richard Allen, which I think is the right thing because that's what he wanted, but the other 2 are denied. Did you expect that?
Hold on. So I think at this point, almost any case holds more weight than wheat. I pulled up wheat for us too, so we can look at that. All right, here we go. Hi, Rowie. John Pryor has to say, sorry, buddy. He was trying to get death penalty off the table and it didn't work. I do believe that's exactly what it was like, well, you can't afford me because, this, that, and the other. But then if, death penalty's not on the table, then I think it'll work. But that's for another day. Okay, here we go.
I did not. I actually kind of felt that they would replace the judge as well to protect transparency and protect the process of this moving forward. It certainly seems, I'm not a lawyer, you both are, that there are still many issues that these 2 attorneys could raise against this judge. And what sort of a relationship are they going to have moving forward? They're supposed to be, all of them, working together to make sure that we have a fair trial for Richard Allen when he goes on trial for these charges of murdering these 2 young girls in Delphi, Indiana in 2017. And there are going to be continued fireworks. This is a case that a lot of the people who have been following it from the beginning, those of us who were at the hearing today, were discussing this, that, you almost can't predict anymore what's going to happen in this case. There seems to be surprises around every corner. And after today, I have a feeling that's going to continue.
I think it might continue. And I too was just a little bit.
I agree with Barbara. Thanks, Bogey, for becoming a member. Okay, so question. Does leaving her on the case leave the door open for a potential appeal in the case the jury finds him guilty on the grounds of her being biased? I'm going to say yes and no, and then I'm going to explain. So, no, because as of right now, everything that's happened in all this pretrial stuff won't be what an appeal would be on necessarily. What they're going to have to do for once the jury finds him guilty is they're going to have to find something within the trial that would show her bias. So that's where things are. Like she can recuse herself saying like, hey, I can't preside over this trial because of bias. She would never say that, but you know what I'm saying. And if she doesn't, and there are things that judicially she makes decisions on that are not correct during the trial, then they would be able to use something like that on appeal. But it would have to be something from within the trial itself. So that's what I'm like, yes and no. Yeah, it's. I know, like Julio said, like we have to wait for the opinion portion of it to see what part's going to be precedent setting. But I think that the way that they spoke this morning really kind of tells us that the precedent setting part is going to be something along the lines of first priority is continuity of counsel. Like that's going to be something like that, because that's what they were all discussing. Now, I think what they didn't all agree on was, how to kick this back down and have them redo this, either having a hearing or, one way or the other. Okay, now let's go back to this. Goodness, man. Okay. Give me 1 second, you guys. Okay, sorry. Had to get
Surprised, Michael, again, that the judge, just to make it cleaner, neater, and given the allegations, that they didn't say, let's have another judge hear this. But you made some great points.
Yeah, I think clearly cleaner and neater are, good reasons, but you also have to have a record. And one of the things that the defense had to do here, Judge, is show the bias. They had to prove it. The judge made that, one of the judges made that point. If you want to claim bias, well, prove it. There was no evidence of bias. That's why I think they left her on the case. But Barbara, what I want to ask you is, there was also, it was brought up in one of the arguments that, look, here's what could happen. If the attorneys are put back on the case, which they were, they go back in front of Fran Gull. One of the reasons I think caused problems for this panel of judges was there was no record of why the judge did what she did. So is it possible that now she decides to have a hearing, and she has a hearing on their competency and ability to move forward in the case?
And then Barbara will end up agreeing with me too on the fact that just doesn't make sense that she would do that, because then you're really looking at some type of bias. But that's neither here nor there. Somebody asked. About, where did it go? I thought I had it up. About the precedent setting in the opinion. So they'll put out a fully written opinion about why they made the decision on both. So even the stuff that they deny or say, no, you can't have, it can also become precedent setting, because it would be like, well, you guys have denied this before, but not in the same capacity. So the full opinion will come out, and then you'll be able to see the legal reasons why they chose to do each thing, and that will become what sets the quote-unquote precedent. But wait! Yes, Steve, Baldwin and Rosie were reinstated, but Gull stays. She's still there. If she goes through with a DQ hearing, they will present evidence that MM was behind the leak and he should be DQ'd. Well, I don't even know if they're going to be able to do it as in like behind the leak itself. Who knows? And there's very good possibility. But one of the things that they brought up in their filings from before was that Barbara McDonald was sitting on court TV holding the Odin report. I mean, I think at this point, my opinion, in my opinion only, my opinion is they all need to let it go. They all need to just go into the courtroom, be professional, and get the trial done. But I don't know. I know. Steve's like, oh my God. Oh, yes, I know. Oh, Barbara. It's being investigated by a private investigator. The leak? Because I know that Rector was still in charge of that for ISP.
creates a record, and still ends up getting rid of them. That's a possibility.
That absolutely is a possibility, and that, as you mentioned, was discussed in court today. And again, you know, I don't have the legal background that you folks do, but it certainly seems that the issues that already existed between this judge and this defense team.
Okay. I totally get what you're saying now. Yes, I understand. Yeah, I'm on the same page. It took me a minute to get there, but I picked up what you were putting down.
Today doesn't fix all of that. So I see that they're still going to have issues moving forward. Again, Richard Allen's trial is set for October in Carroll County with Fran Gull as the judge and Bradley Rosie and Andrew Baldwin as the defense attorneys. But a lot of things are going to happen prior to that. Also, you know, the new defense attorneys that were appointed by Fran Gull when she got rid of Bradley Rosie and Andrew Baldwin, they also filed a motion to have Richard Allen transferred out of the prison where he's being held and put into a county jail, citing his inhumane treatment, that he's being treated like Hannibal Lecter. That's very similar to complaints that Bradley Rosie and Andrew Baldwin filed in the case as well. So, you know, there's so many issues that are still up in the air. Today does not really settle very many of those issues at all, but it gives Richard Allen the attorneys that he wants representing him back. These are two attorneys that have come out and said they believe he is innocent and that they are going to prove it. They say they are mounting a third-party defense, and they are going to blame, apparently, these members of this Odinist group who they say the law enforcement failed to investigate. And it looks like they're certainly going to be pointing the finger in that direction.
If you would, tell us also, Barbara, what it was like in terms of the atmosphere of local reporters, who all was present watching this, because this has captured the attention of the world. It was such a long time before they even arrested a suspect. And so what was that?
I love that. But wait. That's going to be like my favorite thing forever now. I'm going to be like, but wheat. You got to give me something besides wheat. Can we go outside of wheat? But wheat. But wheat, there's a wheat. Freaking wheat.
That feel like in that courtroom?
You know, this was obviously a much more I think, professional setting than some of the others that I've attended, because this was at the Supreme Court. There were very strict rules placed on the media as well as the public who were attending. And I think everyone behaved in a way that really honored that process and honored the court and these justices, and allowed these attorneys to come in and argue what they needed to argue today and have the justices ask questions. And as you saw, the justices had a lot of questions. There were times that they were talking over each other to ask questions of these attorneys. So the fireworks in this case are not going away anytime soon. It's going to be an interesting process to see how this plays out. It has certainly sparked an interest in me to learn more about the Constitution and our rights and how these courts operate at the Supreme Court level.
They bring
We are really grateful, Barbara McDonald.
The Supreme Court out there in Indiana.
So, but wheat. So, yeah, t-shirt time. The front of the t-shirt has Odinite with a rock, and the back of it says, but with a piece of wheat. But wheat. It's an Odinite, but wheat. Oh, I bet Gull is mad. You know who I was thinking of, though? How did Librado and Scremin get the news? Like who delivered the news to them? Like, that's what I want to know. I want to know who told them, because I want to know, well, one, I want to know who told them, and then two, I want to know what their reaction was. Like, how pissed were they? Barbara does sound very neutral today. She absolutely does, because she was hanging out in the Supreme Court where the Supreme Court justices were like, yeah, what she did, what Judge Gull did was wrong. You can shake your head all you want to, Mr. Wheat, but I know that it was wrong.
Again, 2 out of the 3 denied, but ultimately, I would imagine one of the more important ones was getting these attorneys put back on his case. Richard Allen gets a big win there.
I knew it was going to happen when one of the justices said, what difference does it make? Because if a defendant has the right to represent themselves and have no attorney at all, why can't they choose an attorney that the judge may feel violated some sort of gag order? Once one of the justices said that, I knew it was going to lean towards reinstating those attorneys back. And I think that judge really abused her discretion, and she didn't have a hearing. So maybe now she'll decide to do a hearing, to conduct a hearing, to determine if they in fact violated the gag order and if they're incompetent and cannot fairly represent him. I don't think she'll do it, but that decision was proper. I think she overstepped her boundaries by making this decision in chambers and basically threatening them with embarrassment and humiliation and not giving them a time to be ready to fight to keep the position even after those pictures were leaked. They did right. That decision was on point. I think they should have removed her too, because somewhere along the line there is going to be some really tough rackets between them during the trial, and it's always going to be like, she's ruling against me because I embarrassed her in Supreme Court and we got reinstated. There's always going to be an underlying beef between them, and I agree with Ashley, to Judge Ashley, to keep it clean, they should have just removed the judge as well, not because she did anything super wrong, but just to avoid the beef that I see coming down the line.
Yeah, it'll be interesting, Judge, to see the written decision, the reason why they left the judge there. I don't think they found anything in the record to suggest that she overstepped her bounds. Again, I believe that there was nothing in the record to show why they should have gotten rid of her, because there was nothing in there to show that she was actually biased. She had reasons to get rid of them, at least in her mind. Were they sufficient? They don't know, because there's no record as to her reasons why she thought they were grossly incompetent and should not continue representing him.
But that's the very problem. Don't do it back in chambers where you don't have a record. If you feel that strongly and you have evidence to support it, you protect yourself, quite frankly, and get out there and put it on the record.
I love that these guys are like, they're so on board now with the fact that she made a mistake. I think it would be a very interesting live to go back and see how many of these guests, or even like the hosts of these types of shows, not just saying like Court TV, but just in general, have now really just realized, like, you know, she doesn't get to just do things at her discretion just because she wants to. She can't just go around doing things sua sponte. And they're like, now she's like, they're like, oh yeah, she made a mistake for sure. Like, no doubt about it. That's exactly what went down. And before, they're like, no, she's the judge. It's her courtroom. And I know, like I'm saying, I do not mean these people in particular, because I have no idea. I just remember listening to them, people in general, saying that. I think they upped the charges because they can't prove RA is BG. Well, so that's a whole nother can of worms. The timing of that. I don't even know what they're gonna happen. I was away for a while. What happened with the strike? It's gone. I won. They lost. Oh, that's what I was going to ask. Who said that? Was it? Oh, the Royal We. I got halfway through MS's first of 2 podcasts released today. Okay, I have not listened. I've obviously been live like literally all day, pretty much. So are the 2 podcasts that came out today, are they about what happened today in the Supreme Court? They probably did one after the hearing, and then they did one after, like I did, with the 2, maybe. I have not listened. I'll be very honest. I really haven't listened much to them at all now. I probably will, but I've kept you guys informed all day. I'm trying to stay informed. Okay, so we'll let go of that one, and then there is another one. This is one that ATS sent. From freaking Wish. Let's see if it'll play. No, don't do it. No, I don't want that. Okay, hold on. I may have to go back in and grab the link again because it doesn't want to play now.
McCoy and Circle City Broadcasting Group. What is being?
Okay, I'll just go grab the link again. Give me a second, guys. Okay. Here we go. Might have an ad first. It's like the sound of silence. Where in the heck did my volume go? There it is. Okay.
Of Richard Allen, they're giving him his original attorneys back. I-Teammate's Cody Fiser was inside the hearing. He breaks down the legal arguments that led to the Supreme Court's decision.
Both sides fielded very tough questions from the Supreme Court justices here at the State House. And one of the concerns that the judges have is the massive delay in the case that is caused by the removal of Allen's attorneys last October. The attorney representing Richard Allen argued that the decision by Judge Fran Gull violated his Sixth Amendment constitutional rights.
My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy.
Baldwin was eyeballing the camera there. Did you see that? He's like, I know I'm being recorded. Look at him. Like, he's like, I know that camera's pointed right at me.
Developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority. This is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case whether we go into the courtroom or you stay in here.
The attorney representing Judge Gull leaned heavily on a 1988 Supreme Court case, Wheat v. United States, that covers when a judge can remove a defendant's attorneys when there's a conflict of interest. Several judges on the state Supreme Court questioned whether that case applied to this situation.
What can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has
under Wheat. You know what I want? I have to give a shout out to one of my very, very dear friends who I've missed for a very, very long time. Amanda Zbita is in the chat. If you guys don't know her, you were missing out, but she hasn't been around for a little while, so I'm just so happy to see her beautiful face. So thank you for being here. You asked what happened. The Supreme Court ruled that Richard Allen's original attorneys would be back on the case. They ruled with like 3 hours and 40 minutes of once the hearing was over. But I was going to say I'm going to totally a bad idea, and I hope they don't listen. Don't listen to this, Brad and Andrew, that they went into court like with like a piece of wheat, you know? Like how like the farmers, like they chew on like their little corn stalk, or they chew on a piece of wheat. Like if they just had something to do with wheat. That's what I want. Like something to do with wheat. Yeah, this is about like a Bob Sox. This is Bob Sox right there. It's fancy. One nation under wheat. I know, he just would not leave the wheat alone.
to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material.
In rebuttal, Allen's attorney challenged the state's argument.
Conflict of interest doesn't apply, and that's what Wheat is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here.
Ultimately, the Supreme Court sided with Richard Allen, giving him his attorneys back. Reporting Indianapolis, Cody Fiser, Wish TV, I-Team8.
Wish TV is your education station and every...
Oh, I'm talking to you guys and I'm muted. Yeah. What the Wheat? I swear to God, he says Wheat one more time. I hope that Schmid, I don't know if you're still here listening, But Shamita has a channel where she just posts like funny shit like that about like true crime. And she earlier today, she's like, I'm gonna go and just clip how many times that the word wheat is said, and just wheat. I can totally see it in my mind now, like how she would put it together, and it just already has me cracking up laughing. What the wheat? We've got to move on from the wheat. Can you give me something else? But wheat. Speaking of wheat, here I'll give you guys a little wheat right here. So here's the decision from the United States Supreme Court about wheat. You guys, do you want? Have we had enough of this today, or should you want to read through it? You want me I can just link it and you guys can take a look at it if you want. Probably too much. Probably just too much. Too much wheat. Okay, let me go to the other piece. They took a poll and decided we the people. No wheat. But the wheat. You don't understand. You don't understand Supreme Court justice, but the wheat. So the wheat ultimately literally has no, it actually makes no sense why they even used it. So I won't go through and I won't read it, but I'm going to tell you guys right now, it literally makes I will put it in the chat for you guys to see if you choose to read it. It has no bearing on what they were talking about today. I mean, like, I think we all eventually got that as the day went on, but like reading through it, I'm like, what? Okay, so then a side case, the third mini case in all of this nonsense is about Mitch Westerman, who took the photos from Baldwin's office, so on and so forth. So he was in court this morning as well for just like a status conference, a pretrial hearing. They went over just all the discovery stuff, all the stuff that we'd already kind of went over in yesterday's live. But I thought I would just give you guys the update from this. I don't know what these ads are, but it's weird. The Westfield, Indiana man accused of leaking documents connected to the Delphi Murders case is due in court on Thursday. Online records obtained by Mitch Westerman will appear before a special judge in Johnson County 9 a.m. for his pretrial conference. This isn't the one I want. Where's the one that's got the update? Shoot, sorry, I grabbed the wrong one. I want the one that actually tells us what happened. Give me a second. I think it's this one. I think it's this one. What does any of this have to do with the price of wheat? Okay. This is the one. Man accused of leaking evidence in the Delphi murder case appeared in court Thursday. Mitchell Westman is charged with one count of conversion, a Class A misdemeanor. And during Thursday's brief proceedings, his pretrial was set for March 7th. So Westerman is a friend and former coworker of Andrew Baldwin, one of the lawyers appointed to defend Delphi murder suspect Richard Allen. According to the court documents, Westerman admitted that he used his phone to take photos of evidence in the Delphi case without permission. It happened while he was at Baldwin's office. Some of the evidence included sensitive crime scene photos. Westerman shared the photos with a Fisher's man who sent the leaked evidence to someone in Texas. It then ended up in the hands of a YouTuber and podcast creators. The Fisher's man who initially received the evidence later took his own life after being questioned about the leak, according to the court documents. The evidence leak, which came to light in October, marked another stunning turn in the case, leading Fran Gull to remove Baldwin and Rosie from the case. That decision set off a flurry of legal filings with the Indiana Supreme Court, hearing the oral arguments. So I said earlier, I don't know if it was here when I was hanging out over at It's a Crime and Shame, but I said March 6th. It's March 7th. So he has a new pretrial set for March 7th. So that's an update on that. We went over some of the information from his most recent documents, and hopefully when this is all said and done, we'll be able to get access to the police reports and videos, and we'll see what they weigh out there. Because I'm still not sold that there's not two sets of photos. I'm not sold that there's not two separate leaks. I can't prove that. So, I mean, it is what it is. As of right now, we only have the one. The rumor was going around, remember, when this all started happening, that law enforcement was investigating this leak back in August, September. So if that's true, then it had nothing to do with the crime scene photos being sent out in October. I mean, I'm sure that probably pushed it over the edge. But if they really were investigating in August and September, we're going to see that. So I think it'll be interesting to see kind of how everything went around. But another, you know what, I should have pulled that up. Let me see if I have it. But so we were talking, so when Sleuthy was on yesterday, her and I were chatting about, Mitch Westerman essentially signed an affidavit and said, hey, I did this. I went in there, I took these photos, and I sent them out. Like, I did. That's what I did. I took the crime scene photos. But when I'm listening to the wording and like paying more attention to it, where did they have that at? You know what? I think it was actually in the Court TV one. Let me see if I still have that one up. I think when he comes back up, I think they might read it here, so I don't have to pull up the whole darn stream.
And protect the process of this moving forward. It certainly seems, I'm not a lawyer, you both in Delphi, Indiana in 2017.
Say, let's have another judge
to prove it. The judge made that, one of the judges made that point. If you want to claim bias, well, prove it. There was no evidence of bias. That's why they left her on the case. But
come in and argue what they needed to argue.
Well, so I wish I had pulled it up, but I didn't. In Richard Allen's statement, where he talks about that he wanted to keep Baldwin and Rosie, it talks about more than crime scene photos. Dang it. I swore they played that part. Maybe I'm wrong.
In Delphi, Indiana in 2017, the court after they were exchanging the same at the Supreme. Correct.
Did they not play the
Allen, which I think is Richard Allen, which I think is the right thing.
Just moving forward. I have.
And one of the things
now I'm
that
just annoying myself. But yeah, photos and other documents. Let me just see if I can find. I still am trying to organize all the old docs, but I think I might just have that in my photos. I think I may have a photo of it. So let me just double check real quick so I can just read it verbatim. Because that makes me think that it was in the last 5 minutes of his rebuttal, right? Maybe I'll just pull up my own stream. Nope, I think I have it right here. Here we go. Okay. Please accept this letter as confirmation that I have communicated with my attorney, Bradley A. Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. That's number one. I am aware that images of crime scene photos and other related documents were taken by a friend and former employee of Andrew Baldwin and at Attorney Baldwin's office. I don't know if I really paid a lot of attention to that before, but it is crime scene photos and other related documents. So that very well could be why they, somebody was actually already looking at this back in, August, September. Like the rumors were saying that because, remember, I don't know if, did I go over those here? All of Fortson's commentary on Reddit, where he was like kind of pushing some stuff out. My guess would be that somebody kind of caught wind that this person has stuff that they maybe shouldn't have. And then it's kind of started to come from there. And then all of a sudden the crime scene photos became like the thing. It was like it was like the wheat that broke the camel's back. But So I just think that's interesting. And other related documents, because we talked a lot about all the people who were out there saying that the Franks memorandum was about to come out. Sing. I know, it's so bad. So anyway, that's really what I've got for you guys. We've been on another hour. I'm going to wrap it up. I'm going to go and I don't even know what the heck I'm going to do. I'm going to go sit down and probably not look at anything Delphi related for a little bit. That's a lie. I'm just going to lie because I you know damn well I'm going to. But I wanted to come on. I wanted to go over this stuff with you guys. And I think we're going to start to see. I was like, okay, I'm going to finish this Prezi and I got to get all the docs in there. It's like one of the last things I have to do, and all the videos and interviews. Those are like the last few things I need to do with this Prezi. Hold on. I think I have it up somewhere. And I was like, okay, I'm going to get all that done. And then we're going to have a break, and I'm not going to have to do Delphi for a little while. And I can actually like get back into some other of these cases because like, the Daybell stuff's going on right now. We've got the Michelle Troconis trial. Now we've got something to look forward to with Scott Peterson. I know that many people are just going to be like, Scott Peterson's guilty. I'm probably not going to be the channel for you when it comes to that case if you're adamant. Because I'm not, that's another one that I'm just like not adamant on. But I was like, this is almost done. Like we can go and look at other stuff. So I really wanted, I need to finish. Oh, that's 3 things I need to finish. I need to finish the timeline. I need to put all the interviews in and all the court docs and finish Richard Allen and Keegan Kline. That's where I'm at. So, well, he was found guilty. Yeah, but if he gets a new trial, I mean, I don't know. The Innocence Project is taking him on. But yes, I can't do the whole like he is innocent until proven guilty thing. I still find it hard to believe that this was a thrill kill. I think this guy has more skeletons in his closet. I'd like to hear from him. I'm not sold that Richard Allen isn't the right guy. I'm not there. I think that there's a couple things that once we learn some of the timing, the accurate timing, it's going to push us one way or the other. So and there's so much still. So anyway, so like I have like a few big things left to do on here, and then I was done with it. But now I think that we're going to be rocking and rolling. I think we're going to start going pretty quick. No, I didn't. I haven't seen anything. I watched Crime and Shame, and I watched some Bob Mata. That I think, and then I watched Court TV. Did I watch anything else? I think that's it. I'm open-minded about Scott, but it would take a lot. Does he have BG in his basement? Yeah, kinda. What the fuck? I don't know about that, because I don't feel the same way, Heather. I don't think that, for me, I'm going to say this, and then you guys are going to be like, I'm never coming back here ever again. Then I'll see you guys tomorrow. But for Scott Peterson, I do not believe that Scott Peterson got a fair trial. I think that there was a lot of problems with the information that was presented, and I think there was a lot of problems with the jury. Now, I would like to see the evidence completely laid out so that I can make the judgment on whether I truly believe that Scott Peterson is guilty or not. Obviously, right now, legally, he is guilty, just like legally, Richard Allen is innocent. O.J. Simpson, on the other hand, I'm not sold that he's innocent at all, really. I don't think he was alone, but that's another story. And another one is Casey Anthony. I don't care how many times the woman said she wasn't guilty in a court of law. That woman is, she is responsible for the death of her daughter. So sometimes he gets it right, sometimes they get it wrong. But that's where I'm at. So I don't even know if I think that he's innocent, if Scott's innocent. I just think that there's so much that wasn't put on the table. But that's me. And yeah, Casey's pure evil. See, we agree on that. That's why you guys are going to come back and hang out with me again. I'll see you guys later. Now, this time, really go enjoy the rest of your Thursday. And the courts are closed. There should be no more documents coming out, at least until tomorrow. All right. Bye, guys.